Hi, if you don't know me already, my name is Michael Burgis. I'm an attorney. The purpose of this video is to let you know what a deposition is and to go over some general rules for the deposition. Keep in mind, these are just general rules. Each rule I'd want to gear it more specifically to the fact pattern, but these are general rules. Let me first off tell you what a deposition is. A deposition is simply a question and answer session. That's all it is. When your deposition is being taken, the opposing counsel wants to know what's going on with your case. It is a question and answer session only. That's it. Let me tell you why your deposition is being taken. Generally, there's two reasons. The first reason is they're here to make an evaluation of you as a witness. Here's the theory. If you're a good witness and we have to take this case to trial, a judge is going to like you and likely rule in your favor, in which case the defense attorney is going to be more likely to want to settle your case. Now, inversely, if you're a poor witness, the judge is going to dislike you, likely rule against you, and the defense attorney is not going to want to settle your case. The defense attorney is going to want to take you to trial because they're going to think they're going to get a better outcome. It's very important you be a good witness, and a good witness is very easy. You generally have to follow two things. One, be absolutely honest, and two, do your best to follow the rules I'm going over with you. Now, the other reason why your deposition is being taken is they're here to get information about your case. But it's important you realize that the person taking the deposition today is the defense attorney. They represent the insurance company. Their interests are adverse to yours. The reason why they're taking your deposition is they're here to get information to harm your case or information to reduce the value of your case. So it's very important you realize anything you say can and will be used against you. So the general rule is the less we say, the better. Now, you do have an ethical and legal obligation to do your best to answer the questions they're asking you, but a deposition is not a forum for you to talk. Tell your story or get your side out. We don't have to get the good facts down for your case here today. I know those facts. My office will know those facts. We'll argue it in front of a trial judge if we need to. Like I said, a deposition is not a forum for you to talk, tell your story, or get your side out. The less you say, the better. It's important you realize that this is a question and answer session only. When you hear a question, before you do anything, take a few seconds and think about the question and then respond. This is very important. This is going to allow a lot of things to happen here today. First off, I want you to let the defense attorney completely ask their question. You're going to know where they're going with a lot of these questions. You're going to have a tendency to want to answer the questions before they've completely asked them. Don't do that. Let the defense attorney completely ask their question, take a few seconds, and then respond. Because if their question changes at the end, you could be giving an answer to a different question and it could harm your case. The real reason why I want you to take 1 or 2 seconds is so that you can really think about the question, listen to the question, and concisely answer only the question they're asking you. Now, first major rule of the deposition here today. This is going to be a reoccurring theme in this preparation. If you're going to remember one rule from this preparation, it's this rule. And that is you need to be absolutely honest. That goes for every single question here today. Try not to think of this as what's the right answer or what's the wrong answer, or how can I word this to best help my case. That is a gray area. It's going to get you into trouble. All you have to do is listen to the question and answer it honestly. Now, second most important rule of this deposition is I want you to concisely answer only the question that's being asked. Now I'm going to repeat this because this is where every single one of my clients has problems. And in fact, my more intelligent clients seem to have more of a problem with this. I'm going to want you to answer only the question that's being asked. For instance, if I asked you, do you know who the President of the United States is? Now, how many of you out there wanted to answer with Obama? That wasn't the question I asked you. It wasn't who is, it's do you know? So the correct answer there should have been yes. Then let me ask, well, who is the President of the United States? And then you can say Obama. Okay, it's very important. Now you might think if I make the defense attorney have to ask me multiple questions to get to the answer they're looking for, that you're going to be in the room or in the deposition for a longer period of time. That's actually not the case. The more concise you are, and when you answer only the question that's being asked, you're going to be in there for less time, okay? It's when you volunteer, explain, or clarify, you get the defense attorney additional information they may have not got on their own, which leads them to ask additional questions or go on into tangents, like I said, that they wouldn't have got on their own, okay? So it's very important. Be honest and concisely answer only the question that's being asked. Now, generally there's 4 main responses I want you to try to stick to today. Yes, no, I don't know, I don't remember. Those are the four main responses I want you to stick to. Try to think those are the guns that you're going to stick to, okay? Now, yes or no questions. It really depends on the defense attorney. But sometimes 50, 60, 70% of every question here today can be answered with a yes or no. So I want you to treat this as a game. When you hear a question, after you take a few seconds and think about the question, I want you to think, can I answer that with a yes or a no? If you can, please do so. It's the most concise way to answer their question. You're only giving them one word. And like I said, you're only answering the questions they're asking you. So if you can use a yes or no, please do so. Maybe they ask you about a prior injury. For instance, let's say your claim revolves around injury to your back. And they ask you, prior to sustaining these injuries, did you ever complain to a doctor about back pain before? Now, if you think the answer is no, but you're not entirely sure, maybe when you were very young, you fell off a bike and told the doctor somewhere about back pain. Rather than saying no, what I prefer you to do in that situation is say, not that I remember. The reason being is the defense attorney, if they have information indicating that you did have a prior injury and you didn't recall it, if you said not that I remember, it's less damaging to your credibility versus saying no. As a general rule, you need to assume the defense attorney knows the answers to every single question they're asking you. And for the most part, the good ones generally do. The reason why they're asking those questions is they're trying to catch you lying. Now, in workers' compensation claims, and in fact in pretty much any claim, everything revolves around your veracity or your honesty. Okay? You have to be absolutely honest for every single question. Like I said, assume the defense attorney knows the answers to the questions they're asking you. Now, if you can use a yes or no, please do so. And if you think the answer is no, but you're not entirely sure, I'd rather you say not that I remember or not that I recall, okay? Now, if you can't answer a question with a yes or no, such as if they ask, describe something, I generally want you to answer that as concise and brief as possible. My general rule is every question here today can be answered in 5 words or less. Now, there are a handful of questions it's okay to say more than 5 words, and I'll get into those in a second, but as a general rule, every question you hear today, take a few seconds, think about it, and answer it in 5 words or less if possible. Now, I've said this to some of my clients, and I've caught them in a deposition taking a very long time to answer a question. It's because they're trying to get a very complicated sentence down to 5 words. It's not the end of the world if you use 6, 7, 8 words, okay? That being said, I want you to be in a habit of concise, brief responses. Think of it this way. Every word you give in here is extra ammo they can use against you. So we want to give the defense attorney the least amount of ammo possible. So as a general rule, try to stick to 5 words or less. If you don't know or you don't remember, those are perfectly acceptable responses. But like I said, what I don't want you to do is say you don't know or you don't remember if you really do know or do remember. I'm going to give you literally the worst example I've seen of this in my entire career. I had a deposition of a client. The defense attorney asked what her birthday was. She said, I don't remember. She did this because she hated this defense attorney. She didn't want to give that guy any information. Now, while I appreciate where she's coming from and not wanting to volunteer information, everybody knows that she knows her birthday and she's lying. Now the defense attorney is going to want to show that she's lying. In fact, she's lying under oath, and they're going to want to take her to trial. It's very important. I want you to be absolutely honest, and if you know the answers to the questions, you're going to give them. But if you don't know or you don't remember, perfectly acceptable responses. Now, if you don't remember an answer, they are entitled to your best estimate. While they're entitled to your best estimate, they're not entitled to a guess. Let me tell you the difference between the two. An estimate is anything you have personal knowledge on. In most cases, you're dealing with work-related injuries or non-work-related injuries, but you're dealing with injuries. If they ask you about your pain or symptoms, or when you first started noticing these pain or symptoms, or when you went to a doctor, these are all things that happen to you. You have personal knowledge on, and you can give your best estimate. This comes up all the time with dates. If you don't remember an exact date, you simply say, I don't remember an exact date. If they ask for your best estimate, because you have personal knowledge, you can do your best to give them an estimate, whether it be a week, a month, a year, whatever your best estimate is. If you're going to give me an estimate, I do want you to give an indication that you're giving an estimate and not an exact answer. So say approximately, or my best estimate is. Now, I don't want you to guess, and that's something where you have no personal knowledge. Let me give you an example of this. If I asked you to tell me the length of the desk that's in front of me. If you're sitting in front of me and you can look at it, you'd have personal knowledge, so you can give me your best estimate. However, if I ask you to tell me the length of the desk in my home, could you do that? You can't. Assuming you've never been to my house and you haven't seen it, if you gave me an answer, you'd just be guessing. Another example is if I asked you to tell me how much change was in your pocket or money. You can give me your best estimate because you put it in there. If I asked you to tell me how much change I have in my pocket, can you do so? You can't. Good. Now, I'm going to ask you a few questions. It's going to be a little bit more difficult because I don't have you in front of me, but I want to give you an example to give you an indication about whether you really know the difference between an estimate and a guess. Now, if I asked you, do you know how old I am, how would you respond? Your response should be, you don't know. If I asked you, can you give me your best estimate, your answer should actually be yes. Now, a lot of my clients would have just thrown out an age. Someone the other day told me I looked 45. I assure you I'm not 45. Someone the other day told me I looked 25. Unless I'm Doogie Howser, I'm not making it through law school by the time I'm 25. Doesn't matter, okay? As long as it's your best estimate, you can give it, okay? But if I asked you, do you know how old my girlfriend is, how would you respond? The answer should have been no. Can you give me your best estimate? The answer should be no. A lot of my clients will throw out an age. Usually somewhere close to mine, for whatever reason, usually a little younger. It's a pure guess, okay? You have no personal knowledge unless you've seen her. Maybe I have an older girlfriend who paid for all my law school. I wish that were the case. I met her in law school and she's just as much in law school debt as I am. Okay, good. So I just want to make sure you understand the difference between an estimate and a guess. Now, another very important rule of this deposition is I don't want you to answer a question you don't understand. Very important, okay? If you answer a question, it'll be presumed that you understood the question and will be stuck with the answer you've given. So if you don't understand a question, don't answer it. What I want you to do is first ask the defense attorney to repeat the question. If they repeat it and you understand it, great, answer it. If they repeat it and you still don't understand it, I want you to ask them to rephrase it or change it around. Now, while the defense attorney is here to get information to hurt your case, they're really not in here to trick you in answering something you don't understand. So they'll be more than willing to repeat it or rephrase it. So don't hesitate to ask. Now, earlier I told you I want you to be concise. 5 words or less. That went for every single question except generally 3 questions. Now, in the following 3 questions I'm about to go over with you, it's okay to say more than 5 words. That doesn't mean it's okay to speak on the, give an answer that's 10 minutes long, but it's okay to say more than 5 words. Okay, I still want you to concisely answer the question, but like I said, it's okay to say more than 5 words. The first question is when they ask you, what are your current pain or symptoms? This is an extremely important question here today. Let me first off tell you why it's so important. Generally, in a claim for personal injury or workers' compensation, the way I'm able to obtain a settlement for a client is based on a doctor finding they've sustained some sort of permanent disability due to their injuries. Now, if I have a claim and the claim is for the low back, and in this deposition the defense attorney asks my client what their current pain or symptoms are, if they don't mention the low back, and I later go to argue that there's some disability to my client's low back, the defense attorney is going to say, well, why am I going to pay your client for disability to the low back in the deposition? They didn't even mention it, okay? Very important. When they ask you your current complaints and symptoms, we have to get everything out. Now, the word current does not mean this second. The word current, I want you to treat that as in the last month or so, okay? So when they ask you your current complaints and symptoms, I need you to start with your head, work your way down your body, just list every body part, okay? Once you've listed the body parts, then indicate some of the other pain or symptoms that may not be indicated in those body parts. Things like sleep problems, emotional complaints, dizziness, just things like that. So literally, it's just a checklist. Start with your head, work your way down your body. Let's say I have an example of somebody who slipped and fell and injured a bunch of their body parts. They're also taking pain medication, it's affected their stomach, they're having sleep problems, and they're having stress, depression, and anxiety due to the physical pain or symptoms they're in. If they ever asked what their current pain or symptoms are, it would go something like this. Head, neck, low back, left leg, sleep problems, emotional complaints, sexual difficulties. That's it. It's literally a checklist. Start with your head, work your way down your body, just list the body parts. Another question, it's okay to say more than 5 words, or when they ask you about your job duties. This is very important. When they ask you about your job duties, I don't want you to just simply tell them your job title. I want you to go over briefly all the physical things you did. This is very important for a few reasons, and it really depends on your type of injury. If your injury is a cumulative trauma, that's just as the result of doing your daily job duties over and over again, like carpal tunnel due to data entry, you work as a loader unloader and you have a back injury. It's very important you say all the physical things you do because one, I want to put the defense attorney on notice how it is you can sustain a cumulative trauma injury. Irrespective, I want the defense attorney to know how physical your job duties are because depending on the level of impairment, I may be able to get your permanent disability increased depending on how physical your job is. So as a general rule, if they ask you about your job duties, it's okay to say more than 5 words. Tell them briefly all the physical things that you do. The next question it's okay to say more than 5 words are if they ask you about your impact of your injuries on something that's referred to as your activities of daily living. Let me tell you why this is important. In workers' compensation, partially the basis of the award is based on how your injuries affect you in the things you do every day. Cooking, cleaning, grocery shopping, running errands, personal hygiene, just the stuff you do every day. So if the defense attorney asks you if your injuries affect you in any of those activities, if the answer is yes, you say yes. If they ask you to explain it, it's okay to say more than 5 words. I want you to briefly tell them all of the problems you have with all of those activities because I want to put the defense attorney on notice how it is your injuries are affecting you in those activities of daily living. Now, I want you to be very careful though. There are 2 questions that sound very similar, but they are different questions. And a good defense attorney is going to ask you these questions. Now, one question is, are there things that you can do that cause you pain or difficulty? Now, the answer to that question is probably yes. And if they ask you what are those activities, it's okay to say more than 5 words. Briefly tell them what those activities are. I want you to be very concerned if the defense attorney asks you the following question. Are there things you can no longer do now that you could do before these injuries? I want you to be very concerned. I generally don't want you to testify that you can't do something if it's even theoretically possible for you to do it. Okay? The reason being is as soon as you testify that there's something you can't do, you make it very easy on the defense attorney to defeat your case. Because everybody knows life goes on. You still have to use those body parts that are in pain or causing you symptoms. But as soon as you testify you can't do something, all the defense attorney has to do is send somebody to videotape you. As soon as they catch you doing what you testified under oath, under the penalty of perjury, that you can't do, now you're a liar. Okay, remember, and as soon as your credibility is gone in your deposition, your case is gone. Very important. My general rule is never say never, don't say don't say I can't do something. I want you to be honest, but I don't want you to exaggerate. And it's very difficult. Let me give you an example of this. I had a client who injured her shoulder. She had been through a lot. She had arthroscopic surgery on her shoulder. So when she was asked, are there things you can no longer do? She said, I can't do anything at all anymore. And I looked at her and then she changed her testimony and said, well, I can't move my right arm. I saw her drink water with her right arm. She opened the door with her right arm. If I gave her a pen and asked her to lift it, she'd be able to lift it. Like I said, I generally don't want you to exaggerate or testify you can't do something if you can, because like I said, you just made it very easy on the defense attorney to defeat your case. Now, if they ask you that question, are there things you can no longer do? The answer should be no. Or for the most part, it's generally no. The reason being is we don't have to tell them about all the pain or symptoms you have when you do activities. I just want you to be very careful about testifying that you can't do something if in fact it's even theoretically possible for you to do so. Remember that your deposition is based on your memory. If you don't remember an answer, like I said, indicate that you don't remember. What I don't want you to do is say, I don't remember, but I have that information in my wallet, or I have that information in my purse, or I have it at home. Remember that we're not here to volunteer any information. If you don't know or you don't remember, simply say you don't know or you don't remember. Now, if the defense attorney asks you if you have any information at home, I want you to be careful about this question as well. I generally don't ever want you to lie here today. In fact, I don't want you to lie. But what I don't want you to do is say, yes, you have information at home. Let me tell you why. Let's say, for instance, an attorney asks you if you remember the name of a doctor, and you don't remember the name. Then they'll ask you, do you have that information at home? And you think, well, I got his business card at home, so you say yes. What's going to happen is that defense attorney is going to ask to leave a blank in the deposition transcript. You later have to get that card, produce it to my office. We then have to produce it to their office and fill in that blank. that's bad enough because that takes time. And we're here to get you benefits as expeditiously as possible and without encumbrance. Even worse is what happens if you go home and it turns out you don't have it. You thought you had it, but it got thrown away. Well, now we're going to be on the record saying we're going to produce something that we can't produce, and that does impede your case. So as a general rule, if they ask you have information at home, I don't want you to lie. If you think you have it, I merely want you to say I think so, maybe, or no, or I don't know. Just not affirmatively yes, okay? The difference is if you say I think so and you don't have it, we're not on the hook. I'll say my client thought they had it, turns out they don't, sorry. So very important, we're not here to produce or volunteer anything. The only thing I want you to produce generally during the deposition is a driver's license or a form of identification. You hand that to me or one of my associates, they'd review, they'd hand it to the defense attorney. And it also depends on whether they did a motion to produce various documents. That being said, the general rule is we're not here to produce or volunteer anything. Now, let me tell you a little bit about who's going to be in the room in a deposition. You and I are going to be in the room. It's very important that I get this out. Either me or somebody from my office is going to be in the deposition with you the entire time. You have absolutely nothing to worry about. If you're honest here today and do your best to follow the rules, you got nothing to worry about. Furthermore, one of us is either myself or an attorney from my office is going to be in the room with you the entire time. And what that means is if you start to get yourself into trouble, we'll stop the deposition, we'll pull you out, and we'll clear it up. So like I said, you have absolutely nothing to worry about. Now, because I'm going to be in the room with you or one of my associates, I want to make sure I go over a few things with you. Technically speaking, I'm not allowed to coach you during the deposition. I'm allowed to prepare my clients for a deposition, and if you're asked by the attorney if you've had a chance to prepare with your attorney, the answer is yes. If they ask for how long, generally I do it for about an hour, but give your best approximation on how long we're in the preparation. Now, while I'm allowed to prepare you for a deposition, I'm not allowed to coach you during the deposition. Now, be that as it may, I'll do as much as I can get away with because I'm here to represent you. My office is here to represent you. Now, if you see me or one of my associates stick their hand out like that, that means stop talking. That means you've probably already answered the question. You're volunteering too much. You might hear your attorney say, is that a yes or a no? That means that's a yes or no question. You need to give a yes or no answer. Your attorney might also say, did you understand that question? That should be an indication to you that maybe they think you didn't understand the question. What I'd want you to do is ask them to repeat it or rephrase it and listen to it a little bit more closely. Now, that being said, myself or another attorney from my office is technically not allowed to coach you during a deposition. If you need to speak to me or the attorney at the deposition, you can always say, I'd like to speak to my attorney. We can take a break, go outside, and we can talk. Now, while you have the absolute right to do that, I want you to be careful. I don't want you to ask to speak to me or your attorney after every question or every other question, because then it looks like I'm pulling you out, just telling you what to say, and you're coming in and saying it. If you need to speak to your attorney, feel free to do so. Technically speaking, we can't do it while a question is pending. You're supposed to answer the question, and then I can go outside and have a discussion with you. That being said, I don't really care. If you need to speak to me at any time, please indicate so and we'll go outside, okay? Now, I also want you to be careful. If I start to speak in a deposition or one of my attorneys starts to speak in a deposition, you need to immediately stop speaking. I'm likely going to make some objections, or my attorneys are likely going to make objections in the deposition. And like I indicated, if you've already given the answer, my objection is irrelevant. Now, for the most part, I'd likely have you answer most of the questions, but I'm still trying to get my objection noted for the record so I can argue to a judge that the answer is inadmissible. What I don't necessarily want you to do is have you not answer a question, have a judge later rule you need to answer the question, and then bringing you all the way back to answer one or two more questions. Now, that being said, if I start to speak, you have to stop and you need to wait till I instruct you to answer the question before you do so, because there are some questions I will not have you answer. Now, I also don't want you to be concerned if I get into an argument with the defense attorney or if one of my attorneys gets into an argument with the defense attorney. Remember that we're here to represent you. Your interests are adverse to the defense attorney. That can lead me or one of my associates to get into an argument. And we get into our share of arguments. Don't be concerned. Doesn't mean that your deposition is going poorly or that you're doing bad or your case is bad. Doesn't mean that at all. It's just the nature of the adversarial proceedings. Inversely, I don't want you to be concerned if your attorney is quiet during the deposition. Don't think, well, How come my attorney's not making objections? Generally, you want to take your attorney's silence as a form of comfort. That means things are going well. That means the defense attorney is asking appropriate questions and you're answering them appropriately. Now, there's going to be a defense attorney sitting across from you. Very important that you realize this person is not your friend. I want you to be polite and respectful to this attorney because remember, I want this attorney to like you, think you're a good witness, and want to settle your case. If the defense attorney dislikes you, then they're just going to want to be a little bit more aggressive on your case. So it is important that I want you to be polite and respectful, but remember, we're not here to clarify, argue, or explain anything on your case. Short, brief responses only. Now, it might drive the defense attorney crazy. I don't care about that. He should know, or he or she should know that I've instructed my client to concisely answer only the questions they're asking you. Remember that even if we take a break in the deposition, I want you to be careful as well. Don't volunteer information outside of the break. Let me give you a rare example of this that I think will be a good example to clarify what I mean. I had a two-part deposition. The first part of the deposition, my client had a full head of hair. The second part, he had a shaved head. Defense attorney was very nice. We took a little break and he just went to socialize with my client. And he said, hey, what's with the new hairdo? My client then proceeded to say, I didn't honor my father who got diagnosed with cancer. Now, in that little 30 seconds that he volunteered that information, we also had a psychological claim for this client. And I was arguing that his stress, depression, and anxiety is attributed due to his work-related injuries. We went back on the record and spent about 40 minutes on how his father being diagnosed with cancer affected him emotionally, okay? So you got to be very careful. If you take a break, be careful. I want you to be polite and respectful, but don't volunteer, clarify, or explain anything. Remember, anything you say or do in this deposition can and will be used against you. Now, there's going to be a court reporter in the deposition, likely sitting to one of the ends of the table. They generally have two duties. Their first duty is they're going to swear you in. You're going to raise your right hand. You're going to take an oath to tell the truth. It's important you realize that your testimony today is under the penalty of perjury. What that means is if you lie or mislead today, you can be subject to fine or imprisonment. So I can't stress enough, be honest. Now, I've told this to some of my clients and I've caught them lying. Do not make that mistake. It's not good for your own case if you're caught lying here, and they can prosecute you for perjury. So it's not good for your own penal or pecuniary interest as well. So be absolutely honest. Do not lie. Now, their other duty is they're here to type everything down. It's a very difficult job. In fact, in my opinion, it's one of the most difficult jobs out there. So it's very important that a few things are followed. One person needs to speak at a time. The court reporter can't type down multiple people talking over each other, which is also why I want you to let the defense attorney completely ask their question, take 1 or 2 seconds, and then respond. The court reporter is literally typing down what is verbally said, so you must verbally respond to every question. It's human nature to say yes or no by nodding up and down and side to side, and you can do so, but you must verbally say yes or no because they can't type down a head nod. Avoid and as that's confusing and difficult for the court reporter as well. Now, sometimes they ask my clients a question, things like, where does it hurt? And my clients say, oh, it hurts right here, or it hurts right here, and they point to a body part. But remember, the court reporter is typing down what is verbally said, and they're typing down it hurts right here. So when I go to read that deposition transcript a month later, I have no idea where right here is. So if you're going to point to a body part, you must verbally describe it. Now, there could also be somebody here from your employer in the room, somebody like an HR rep. Generally speaking, it doesn't happen, although it does happen on occasion. If they are in the room, they generally can't say or do anything, so don't worry about it. And believe me, if I see them so much as look at you the wrong way and I think they're trying to intimidate you, I'll kick them out of the room or stop the deposition, okay? So generally, don't worry about that. Now, a defense attorney might tell you you're going to have an opportunity after the deposition to review the deposition transcript. The deposition transcript is the booklet that's typed up of all the questions and answers. They're going to tell you you're going to have an opportunity to review this and make changes if needed. Generally, I don't do that. I don't like to make changes in the deposition transcript because it gives the defense attorney to impeach your credibility. They'll say, well, which one was the truth? Was he or she lying then, or are they lying now? We're going to give it our best shot here. And if I need to make a change, I'll do it in front of a judge if I need to. So as a general rule, we're going to give it our best shot. And just as a general recap, Be honest. Concisely answer only the questions they're asking you. Don't volunteer, clarify, or explain anything. Try to stick to yes or no. And if you can't answer with a yes or no, concise, 5 words or less. If you don't know an answer, you don't remember an answer, perfectly acceptable responses. Don't answer a question you don't understand. Ask them to repeat it or rephrase it if you need to. 5 words or less for every question, unless they ask you about your job duties, in which case tell them all the physical things. They ask about your current complaints and symptoms. Start with your head, work your way down your body, just list those body parts, then indicate those things, those other pain or symptoms that may not be attributed to those body parts. If they ask you about those activities of daily living and if you have an impact, tell them all the things that you do that cause you pain or difficulty, okay? We're going to give it our best shot. I don't make changes. If you guys have any questions on preparing for a deposition, generally don't stress. If you're my client, one of either myself or an associate attorney will prepare you 1 hour before the deposition. So this is just to help alleviate some stress and give you an idea of the general rules that I want you to follow. But keep in mind, your attorney is going to prepare you for the deposition 1 hour before the deposition and go over all the specific nuances that are important to your case. Now, if you're viewing this and I'm not your attorney or my office doesn't represent you, and you have a claim that's coming up or you're concerned about a deposition, feel free to give my office a call. The number is going to be below. You can also check some of my other videos and go over a little bit more of the specifics on your case. I have videos that break down permanent disability, temporary disability, how cases can settle, and general overviews. Like I said, we're here to help, okay? My slogan is bringing recovery to the injured, and I mean that in every sense of the word, whether it's monetarily, emotionally, and physically, okay? So I'm here to get my clients the best medical treatment possible. After they get the best medical treatment, I want indication from a medical report indicating they've sustained the greatest amount of disability. That enables me to lock in the greatest amount of compensation for them as well. And then, of course, I want to lock in the greatest amount of future medical care. Remember, our office is here to help. The number's below. Any questions, feel free to call. Once again, my name is Michael Burgis. I'm the managing attorney of Michael Burgis & Associates. The team of attorneys here at MB&A, we're here to help, and we're here to bring recovery to the injured. If you have any questions, feel free to give us a call. The number's below. You can also go to our website, and you can go to our links and look at multiple other videos where I break down other sections of the law. Once again, we're here to help. Please give us a call. We're standing by.